Court, all rise. Circuit Court, Second Judicial Circuit of the State of Florida in Napoleon County is now in session. The Honorable Edward D. Collins presiding. Be seated.
Good morning, Mr. Bundy. How are you? Gentlemen, we ready to proceed?
Your Honor, I filed some preliminary motions which I've given the court a copy of. I understand we can take those up after the court brings in the first 14.
Mr. Harvey, what we basically intend to do is to bring this jury in, or the 14 of them, preliminarily instruct them, and then retire them back to the jury room so you can question them individually, and I'll take those motions right after we give them and get them back, if that's appropriate time. Is there anything that you precede those, or?
Yes, sir, Your Honor. At this time, I would like to object to the placement of the press in these seats in back of the defendant in front of the bar.
Let the record show that the press is seated to the right of the bench in two provided chairs and behind the counsel table for the defendant, but not so close thereto that it impairs any of your conversation. Let the record reflect the objection and overrule it, and we can proceed. Bring the jury in, Mr.
Oh, Your Honor, there is another matter.
Your Honor, Mr. Bundy has a motion.
All right. What is Mr. Bundy's motion? This court considered all this matter yesterday. Let the record show the filing of the motion. And, do you have any argument on it?
Well, yes, I have just a few statements I'd like to address. Principally, Your Honor, to the letter sent to me on June the 1st by Mike Minerva, my chief counsel, which is marked as Exhibit A in the motion. I'll state for the court that Mr. Minerva informed me in that letter and a subsequent conversation that in a conference call he had with you, together with the prosecuting attorneys, that you informed him.
Your Honor, I believe the jury's present.
All right. Let me instruct them, and then we'll take it. May I see the indictment, Madam Clerk? May I see the indictment? Good morning, ladies and gentlemen. Subsequently, the court, counsel for the state and counsel for the defendant will be asking you questions touching upon your qualifications to serve as jurors in this particular case. This part of the case is known as the voir dire examination, voir dire meaning to speak the truth. Now, the purpose of a voir dire examination is to determine if your decision in this case would in any way be influenced by some opinions that you might now have, or by some personal experience or special knowledge that you may have concerning the subject matter that is to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in the courtroom, without being influenced by any other factors. Please understand that this questioning is not for the purpose of prying into your personal affairs, nor is it designed for personal reasons, but its only purpose is to obtain 12 impartial people who will try the issues in this case. Each side has a number of peremptory challenges, by which I mean they can excuse you without giving any reason or cause. If you're challenged by either side, please understand that your honesty or integrity has not been questioned, but it's simply the exercise of a challenge by one of the attorneys for the bases of trying to obtain, in their opinion, a fair and impartial jury. This case is the state of Florida against Theodore Robert Bundy. The defendant is charged by an indictment filed in this cause on the 27th day of June, 1978. The indictment charges 2 counts of murder in the first degree and related counts of burglary and attempted murder. The indictment is not to be considered as evidence but it is a mere formal accusation of the defendant upon which issue is joined. You must not consider it as evidence of the defendant's guilt, and you must not be influenced by the fact that the indictment has been filed. Ladies and gentlemen, the jury selection in this particular case is going to proceed on an individual examination by the attorneys questioning each one of you individually. With those preliminary instructions that I have given you prior to the actual question, I will ask you now to return to the jury room under the escort of the bailiff, and we'll call you in as we begin the actual question. You may now return.
Before the jury is removed, may I approach the bench with you?
Now let the record reflect that the jury is retired to the jury room. Mr. Bundy, you may continue.
Your Honor, I was referring to the conference call that took place between yourself, Public Defender's Office, and the State Attorney's Office on June the 1st, as I've been informed, June the 1st, 1979. Mike Minerva informed me in that letter and a subsequent telephone call I made to Mr. Minerva that because of the scheduling of a competency hearing, the one which we held yesterday, the court had considered that matter and, according to Mr. Minerva, instructed Mr. Minerva that the actual selection of the jury panel would not begin until June the 18th. Your Honor, yesterday we made quite a to-do about not being ready for voir dire, and for good reason. We were not ready for voir dire because we did not expect it to take place until June the 18th at the very earliest. And I think that in good faith my counsel relied upon the representations of the court as to when voir dire was to begin. Now, I understand that there's been some discussion about whether or not we wanted to poll this jury and how that might have influenced the court in deciding to start voir dire selection today. And I think that we should have an understanding from Your Honor as to why we're starting jury selection today. Why we're not starting on June the 18th when we initially thought we were going to begin selecting jury. And why we cannot have a polling today as the court had intended.
Mr. Bundy, everything this court does is by order, and I entered the rule yesterday, so we will proceed. Call your first juror. Here you go, Madam Clerk. File the motion.
John?
Yes, sir.
Does the court want to review those tapes first before we start?
You have tapes relative to what, Mr. Harvey?
Your Honor, news reports aired over Channel 27, ABC, locally, and Channel 6.
They're appropriate to the jury selection, are they?
Yes, sir.
All right.
Your Honor,
Yeah, Mr.
please,
Bundy.
the court. We were served these subpoenas this morning. Channel 6, who I represent, and Channel 27, who's Mr. Cooper is here representing. And I would like to move to quash the subpoenas on the following grounds. The subpoena requests that we produce all news stories regarding Theodore Robert Bundy shown on 6/11/79, that is yesterday. With regard to the stories which we, Channel 6, produced, the decision of the Florida Supreme Court in the Post-Newsweek case issued April 12/79 recites on the next to last page, none of the film, videotape, still photographs, or audio reproductions developed during or by virtue of coverage of a judicial proceeding shall be admissible as evidence in the proceeding out of which it arose, any proceeding subsequent or collateral thereto, or upon any retrial or appeal of such proceeding. So, pursuant to that order, the stories which they've requested, which of course include the tape videotape which was taken yesterday would not be admissible in this cause and
Is
not
that what
subpoena.
was shown, Mr. Harvey?
Judge, there were parts of it shown in the courtroom, and parts of it being a history of the case. We're not requesting that these tapes be introduced into evidence. We want to show these for the benefit of the court in determining
What's the motion for change of venue?
motion for change of venue and motion to sequester the jurors for the remainder of the war document.
And what's the substance of the tapes?
Your Honor, part of it is a history similar to the articles that we brought up, long articles that went.
Was that separable from the actual film shown from the courtroom, Mr. Bunch?
Your Honor, I believe, although the subpoena is not clear, we showed yesterday on 6 o'clock, we showed a piece which was produced by CBS News. And although we have a copy of it, we would take the position that if they want it, it's CBS News' property and that
Mr. Bunch, the problem that we have is probably a practical one rather than possibly even a legal one. I am very concerned concerning the impact, as we indicated during the pretrial proceedings, about jurors being summoned. And I think this the request of Mr. Harvey primarily to show something in the aid of the court. I understand the decision from Post-Newsweek, and I think probably we won't be able to reproduce those. But if you've got other material that was shown that wasn't filmed in the courtroom, it might be of some benefit to the court to see it as probability on their motion.
All right. Well, if I may continue, the story that was shown on the 6 o'clock news last night was produced, edited, and directed totally by CBS News, and we showed it, and we have a copy of it, but and I believe it would be forthcoming if it was requested of CBS News, but we would take the position that it's not our property. And
you have any prohibition of showing? Is there some restriction, or there's potentially some restriction? Is anybody here from CBS News?
A reporter is here from CBS News, yes, sir, Mr. Rabel.
And this was aired over your station yesterday afternoon.
It was, Your Honor.
It's in their possession.
And you have a copy of that tape?
We do, Your Honor.
I think we can probably show it if it's been shown. I don't want you to show anything that wasn't shown to the public.
The other parts, the part that was shown on the 11 o'clock news last night were two stories. One was a story, and those we produced. And if Your Honor does not, having ruled against me on the argument with regard to the Post-Newsweek decision, we would then be willing to produce both of the stories that we showed, one of which has to do with what took place in the courtroom yesterday, and the other has to do with the media coverage of the event and has one brief exchange between Your Honor and Mr. McKeever in it, which was taped in the courtroom. And
That wasn't that heifer dust exchange, was it?
It was, Your Honor.
I sure don't want to see that again.
I think I remember that one, Mr.
So-
I don't believe you need to show me that one.
So we would willingly produce those which were aired. We would have the.
Those which came totally from what you came from the courtroom, I think Post-Newsweek does cover.
Judge, if I just might be heard on that, just for a second. Like I said, we're not asking for this to be introduced into evidence, and I find the press's position really strange because during the pretrial hearings, they're talking about, well, our news isn't slanted, our news isn't going to have any effect on the jury benign, and now they come into court and say, well, now once we're in the courtroom, it doesn't matter whether it's slanted or prejudicial or anything. We don't want the court to see it on the very issue of whether the venue ought to be changed, which they've been recommending that you do if you don't open the pretrial hearing.
Mr. Harvey, how do I disregard Post-Newsweek and the Supreme Court opinion?
Well, Judge, the opinion seems to say that you can't use it as evidence and on appeal or anything like that. We're not asking it to be used or the tapes to be introduced into evidence. We're asking this to be viewed by the court for its own use, whether it wants to use it as evidence or not.
Do you have those here, Mr. Bunch?
The tapes? Yes, Your Honor. We do.
Does the station have any prohibition against the court seeing them?
Yes, sir, Your Honor. I'm John Cooper. I represent WECA, which is the agency affiliate in Tallahassee. My arguments are substantially the same as Mr. Bunch's. ABC, which I think is represented here, ABC National, considers the tapes shown on its national news as to be its property and not that of a local affiliate, and not that of a local affiliate to dispense with and deal. And we have a different story on different situational stories that were produced by the local affiliate and were shown on the air. But particularly with the ABC story shown last night on the national news.
After it's been aired, what is the foundation for which they don't want this court to see it?
I don't think they do not want the court to see it.
I just take a little bit of front to that. I'll tell you quite candidly, we've done everything in this trial possible to make you people accessible to this court proceeding. And if you're going to show something on television to the general public and want to restrict this court from seeing it, I just don't think it's fair.
Of course, my client, Your Honor, will follow.
I understand your client, and I'm saying these words to your client and not to you because I know you represent him. I just don't think it's inherently fair. If it is going to impact a jury in this community that has been shown by you as a result of the labors of this court, I want to see it.
Yes, Your Honor. I don't represent ABC National. I represent the local station.
I don't care if they're PDQ Universal. I still want to see it.
And the local station will, of course, comply with the court's orders, but I thought the court would
I
like to
appreciate
hear
your
that
position. I
statement.
appreciate your position legally, but I think the fundamental concept that we totally and completely have to understand is that we're dealing with something far more sensitive than possible news rights for some future royalty for whoever they might be. We're dealing with this young man's life, and I'm not going to let a royalty in futuro interfere with it. And I hope you understand it. I hope you appreciate
certainly do, Your Honor.
appreciate the substance of what I'm saying.
I think also it's possible to separate out the actual courtroom sequences from the other tape.
I don't want to see anything that wasn't shown to the general public, but if it's got impact on this motion to change venue, I think we have to understand as lawyers, and I hope they understand that we're not trying to invade their province, but we have to see. It's just fundamentally unfair for us not to see. And I certainly don't take any affront to you as lawyers because I understand your position. And I indicated that, I guess, rather strongly because I feel that sometimes your clients really don't understand what we're laboring for, and because of competition, and that's all it's about, and I understand that. But I hope that it's understood that this court wants to find anything factual, anything material to these issues, and we appreciate your representing them, and that's what adversary procedures are all about. But I think you can see the position that we're in, and I'm not going to confiscate anything. I'm not going to introduce it into evidence. That would be a different problem. I just want to see it because having been brought to your fair city by order of the Supreme Court, I haven't had an opportunity to see a television. I don't know what you all said. So Mr. Harvey thinks it has some probability. Maybe we ought to take a look at it, Mr. Cooper, Mr.
Thank you, Your Honor.
And certainly it'll be returned back to you, and I don't want to see anything that wasn't shown to the general public.
That's what we have.
That's all I'm concerned with, and I don't want anything else. But I do think if there is concern that that's probative to this motion, and I would like you gentlemen to confer with your clients at this time. If there's anything that shows up that wasn't shown to the public, we'll immediately take it off.
We have 3 stories, all of which were shown, which were aired yesterday, and we will
I think the court ought to be able to see that. I can appreciate his
We'll comply
motion
with the court's
in
court's
spirit of what we said.
Yes, Your Honor. I'm not sure, we have 2 tapes, and I'm not sure whether both of them, or either one of them, are compatible with this tape recorder, but we'll very quickly...
If you want to view them
find
first,
out.
or your client wants to
I
view them
saw them
first.
on the air yesterday.
Your Honor, I think it may require some editing on the ABC tape to get out the courtroom stuff. Most of the ABC local stuff is courtroom scene. There is some that's not.
Well, don't show me that. I think it's there.
All right, now, I want to do what you want to do, Your Honor. Do you want us to edit out the portions in the courtroom?
I think you ought to take it aside and take it out and edit it out because as I construe those, I know what took place in the courtroom. See, that's the theory behind that.
So you want to see...
I know what took place, and if it's representative proceeding, Mr. Tell, if it's representative proceedings that took place in the courtroom, I really don't need to view those.
Judge, would I, can I just make a point? I know the court's very aware of what happened in the courtroom, of course, but the court is not aware of what was broadcast. Now,
Well, let us assume they broadcast it in toto. That's the position that I would take in considering your motion.
could I ask this, if they edit it out, if they could edit out the picture part of it, we could get around the Post-News Week and leave the
See
audio.
what Mr. Teller has here.
You can leave the audio.
I have the stories which ABC Network News aired, and we have no objection to showing you anything that the public saw.
That's what I'm after, Mr.
I
Teller.
will say that there is some history behind the defendant on our initial piece, and then there are some courtroom proceedings, both. But we have no objection to showing you what we put on the
All
air.
right, let's take a look. That's all I want to see, and that's the only reason
You have
that
to understand that we would have to separate that material if you wanted to.
you need some time to do it, no
Yeah.
problem.
Judge, if they don't have any objection to showing what was in the courtroom, I don't have any, I'd like to stipulate to that.
No, I don't, because I'm
You
not
show the
going to
whole thing,
introduce it
show
into
your
evidence. But I don't think they're going to make that waiver.
Well,
I'm not really interested in seeing what took place in the courtroom. I agonized through that, so I don't need to see it again.
well,
Your Honor, we would have to...
I think it would take a
We'd have to-
substantial amount of time to edit out
Whatever
what's...
you want to do. What I want to see is basically what could have impacted this jury, Mr. Teller.
Your Honor, we could stop it at the portion where we go into the courtroom yesterday.
If you can do that for us and assist us with it, I think it would be of assistance.
Your Honor, I believe, at least on behalf of the materials that Channel 6 and Channel 27 would have produced in the interest, consistent with the order that we show it to you, I think we would just go ahead and show you the whole thing.
In the interest of time, Your Honor, WECA is willing to show its local part in toto. I think it would take less time to see it than it would for them to edit it. I assume ABC wouldn't object to showing
Just
that
what
either.
you've had on. I don't care to see anything else. I don't want to infringe on any work product.